All right, this public hearing is called to order. Today is July 1st, 2024, and it is 1 p.m. Eastern Daylight Time. We're in room W161 at the Indiana Government Center South, 402 West Washington Street, Indianapolis, Indiana. My name is Matthew Brown. I'm the State Personnel Director. Our purpose today is to receive public comments about proposed revisions to the state personnel rules. I'm now going to turn the hearing over to Keith Beasley to 1, give an overview of the promulgation process, 2, summarize the proposed rules, and 3, conduct the hearing in a manner that allows for the orderly presentation of comments.
Thank you, Matt. If anyone is in the room and would like to sign in, I'd appreciate that. We are to keep minutes of these proceedings. And additionally, if you are attending online, you may register your attendance in the comments section. Please do that. That is also the means by which you can make comments. This rulemaking initiative proposes to update the personnel rules applicable to the Executive Department Civil Service System. They are found at 31 Indiana Administrative Code Title V, and they make the following changes. They remove gender-specific pronouns. It removes the requirement for an official transcript certifying all post-secondary education. It permits requests for extension of intermittent appointments. It amends the salary rule 3 ways. First, acknowledging the existence of pay matrices. Secondly, to clarify that pay for work out of class must be at least at the pay range minimum. And thirdly, to reconcile the rule with the state park ends authority to opt into the personnel rules, therefore have certain provisions made inapplicable to tipped workers. Normally, your salary is your total remuneration, and you cannot receive supplemental income from public for rendering personal services to the public. And obviously, tipped workers in food service, that would be an exception should the state park ends opt into the rules. In addition, Rule 8 is amended to clarify that compensation for work on a holiday is straight time pay plus holiday pay. It is the current practice. It permits the use of vacation during the first 6 months of employment. It establishes that restrictions on funeral leave need not continue relative to the funeral leave being taken within 3 days, the 3 next regularly scheduled days on the employee's work calendar. It adds existing policies to the leave rules, specifically community service leave, up to 15 hours for a full-time employee per year, and that 15 hours includes any time engaged in an agency-sponsored event. Secondly, new parent leave up to 150 hours within 6 months of the birth or placement of a child for adoption. And it codifies the promulgated rules, the existing emergency conditions leave programs, which includes time off without loss of pay if there is an emergency closing, such as due to a power outage. And it draws the contrast there with situations in which there are conditions of a serious nature but do not necessitate closing, such as the curtailing of operations as a result of inclement weather or something of that type. Rule 9 is amended to provide that the waiting period for short-term disability is simply told if a person is on a authorized leave without pay, but the provision in the law that says you must work 6 months without a break in service is invoked if in fact the absence is unauthorized leave. There's also a provision to comport with a reasonably new state law on tort disability benefit calculation for correctional officers, increasing their disability benefit to a function of the number of hours that they are typically scheduled to work, excluding, of course, premium overtime. But correctional officers often work more hours than do office workers. There is a incorporation by reference of the statutory limit on the amount that can be paid out on leave conversion at the time of retirement. And within that same rule, there is a updated cross-reference to a statute. The statute itself accepts from the retiree leave conversion, the universities, and the statutory definition of state educational institutions has been recodified since the rules were originally prepared. The rulemaking document goes on to repeal three things: the inactive employee suggestion award program that is now handled through bonuses. It removes the requirement that an employee on long-term disability remain on the staffing report of the employing agency. Let me say that differently. Currently, the rule requires the person be removed from the staffing report of the employing agency, and this would allow them to stay on the agency staffing report. And then thirdly, it repeals a provision that seems to place the onus of record keeping on the appointing authority for both payroll and time and attendance, because that is now done through the PeopleSoft system. All citations in 31 IAC 5 that are not being amended are readopted. In addition, there are numerous stylistic changes that are made by LSA. LSA's editorial style changes over the years, and things that have been previously written to comport with their style requirements are being now amended to comport with the current style changes. Procedurally, again, if you haven't signed in, please do so. The State Personnel Director's authority to adopt these rules is found at Indiana Code 4-15-2.2-19. The regulatory analysis for these proposed rules were approved by the Office of Management and Budget and the State Budget Agency on May the 3rd. Legislative Services Agency issued its authorization to proceed on May the 13th. The Small Business Ombudsman approved on May the 15th. Copies of the rules have been available for inspection at the front desk in room W161 since before May the 29th. Notice of first public comment period, the text of the proposed rule, the notice of public hearing were all published in the Indiana Register on May the 29th as LSA document number 24-179. The agency rulemaking document has been maintained and linked to the State Personnel Department's website. It has been accessed at least 46 times as of this morning. Public comments were invited to be sent to me, and on the first notice of rule promulgation and public comment, they must be postmarked today, on or before today. This hearing is accessible remotely via on.in.gov/VMICX. The text of the rules being considered precisely mirror that which was published in the Indiana Register, with the following exceptions. LSA changes to the pre-publication document that was submitted involve the following things, the following changes that SPD is considering. In Rule 2, under applications, there's a reference to education and training. LSA changed training to education, and this is the more common vernacular that's used in the pre-employment process. Secondly, temporary and intermittent appointments. An intermittent appointment, LSA changed stoppage of public business to prevent a public business from closing. They also changed the phrase, a vacancy of which the appointing authority has had reasonable notice, and removed the conjunction of which. There is also a change to the phrase, no emergency appointment shall be renewed. They changed shall be to is. Under the Rule 2-8 underfill, LSA changed the appointing authority to an appointing authority. Under Rule 5-1, which is the salary rule, LSA changed the reference to the salary upon appointment to their phrase after being appointed. In addition, under the salary rule, There is a requirement for providing notice to the personnel director, and LSA changed the reporting of each change to reporting a change. Next, still in the same rule, there was a provision about work out of class. There continues to be a provision about work out of class. LSA changed the pay range minimum to the lowest pay range. Rule 8, holidays. There is a reference to taking compensatory time off in the same pay period in which the holiday occurred. LSA removed the phrase "in which." Still in Rule 8, under paid leave, there is a requirement for prior approval of certain paid leave for special education and training related to the person's job. LSA changed prior approval to earlier. There is a Scribner's error in 31 IAC 586F. This is the provision that talks about the cap on community service leave and provides that if you spend time volunteering at an agency-sponsored event or another governmental entity or 501c3 charity, that time spent in the agency-sponsored event does count towards your total 15 hours per year that you're allowed. The cross-reference there appears as a reference to subsection C, and it should be a cross-reference to subsection E. And then furthermore, under paid leave, there was a provision on new parent leave. It provides that an eligible full-time employee may receive up to 150 hours. LSA recommended changing request to receive, and that is consistent with the previous sentence, which uses both request and receive. So that's a friendly amendment. There's no concern there. It is just a change in the verbiage. Rule 8-6 is emergency conditions leave. I introduced the rule earlier. Emergency conditions typically result in the closure. There are also circumstances in which conditions of a serious nature exist which do not require closure. And the vernacular that has been used to describe those circumstances is curtailing of operations. And so here LSA had changed the word curtailing and curtail to the words decreasing or decrease. Under military leave, there was a cross-reference to those requirements for reinstatement as are prescribed according to federal law, and LSA changed according to under. Rule 9-4, short-term disability. There is a requirement that a person who returns and performs some other work other than their normal duty is allowed to receive 80% of that employee's base biweekly wage. LSA changed the employee to an employee's base wage. Also in Rule 9, under partial disability, we have a requirement that if a person is performing work other than work of their own class, they must be paid at least the minimum hourly rate for the work performed. LSA changed minimum to the lowest. And lastly, in Rule 9, under partial disability, the rule provided an employee who refuses an appropriate temporary assignment shall be terminated. LSA changed shall be to is. And so that issue remains. Now, everyone is welcome to provide comments on these proposed rules. We will listen. I may take notes as we go on. Again, our purpose is to entertain your comments. It's certainly not a debate. We are, of course, obligated at the end of this process to reply to any substantive comments that are made, but it is now for you to make to give input. The only restriction in the statute is that it be done in an orderly manner. It can be informal, but we do wish to avoid undue repetition. So at this point, let me ask if anyone wishes to be recognized to make comments. If you wish to do so in the room, feel free to speak up. If you are remote and wish to do so online, your best vehicle for doing that is to use the chat.
Keith, I don't think the chat is working on this.
Oh, is that right?
Microphones are disabled.
The microphones are disabled, but I think you're allowed to make comments then.
I logged in, it was not.
You tried to? Kiko, if you're out there, could you just test it for us, please? Just try to type test in the chat. And if it doesn't work, that is understandable. There is, of course, a concern that when the legislature adopted the significant changes to the rule promulgation process 2 sessions ago, they desired that the technology would support remote comments. They anticipated, however, that the technology may not support that, and consequently expressly in the statute afford the governor the option to delay implementation of that requirement, a temporary delay postponing certain technology requirements. Executive Order 24-02 provides that the governor has found that based on some experience in a rule promulgation, I believe from Family and Social Services Administration, that technological difficulties did exist. And so he has issued a executive order that specifically provides that we as an agency are to do that which we are capable of doing, primarily live stream and record these hearings, which is what we are in the process of doing. And inability to comment remotely through this vehicle does not invalidate the rule promulgation process. I would remind you, however, that if you wish to make comments by mail, they should be postmarked by the close of business today, or you may deliver them to the front office in W161 Indiana Government Center South, which is 402 West Washington Street in Indianapolis. And I'll pause once again. Is there any indication in the comments of comment?
Kiko was able to comment, but I think it's just him.
Because he's in-house?
Yep.
Okay.
And I'm in house too, and I couldn't do it. I think it's because it's set up here. Yeah.
Okay, so comments to be submitted. We'll make dockets of the record.
We also, thank you, Kiko. Our communications director reminds me that our rulemaking document remains live on the internet. If you go to state personnel's homepage, you will find under laws, rules, and policies, a menu of options. And the very last item there is the rulemaking docket. And it allows an opportunity to click on a hot link there and take you to a place where you can enter comments that way. The process then is such that consideration will be given to any comments received. And depending upon the scope of those comments, the substance of those comments, we will either republish for additional comments, or we will prepare the rule adoption package, which will include a summary of the comments received and the agency's response to those comments. Thereafter, the rules are presented to the Attorney General, who has 45 days to approve or disapprove the rules, and then to the governor, who is allowed 15 days with a 15-day extension, a total of 30 days to approve or to disapprove. And the rule will take effect 30 days after filing with the publisher of the Indiana Register. Pausing for any other questions or comments.
Seeing no one in the room and knowing that the team's chat will not allow comments at the time, and knowing the comments can still be received, I'd like to close today by thanking anyone who has attended for your attendance and comments. This matter will be taken under advisement and a decision will be announced at a future date. This hearing is adjourned.
Thank you.